All right. Oh, they even got. Y'all need to see this one. I think. Thanks for reminding me about this. So it looks like I'm not getting off after all. Let me share this with y'all real quick. Share. All right, right there is the. This is a case where I think the wife died and the trustee for her trust tried to. And this was actually this year. It says here in 2003, Waltraud, Regina, and Thomas Kramer were purportedly married by a religious marriage ceremony. I told you guys that y'all could do that, right? Though they never obtained a marriage license. The couple subsequently purchased a condominium unit as tenants by the entireties. In 2015, Regina executed a deed conveying her interest in the property to the Waltraud Regina Living Trust. After Regina's death in 2016, appellate Victoria Trapasso, as substitute trustee of the trust, filed a petition to quiet title the property. Basically, try to take the property from the husband. Um, Essentially requesting a declaration that the trust owned 50% of the property because Regina and Kramer were never validly married. The circuit court for Anne Arundel County determined that Regina and Kramer were validly married and accordingly that Kramer was the sole owner of the property by virtue of the tenants by the entirety's deeds. Trapasso timely appealed and presents the following question. Were Kramer and Regina legally married so that Walter and Regina lacked the legal capacity to convey her interest in the real property at issue? Applying long-standing Maryland precedent, we conclude that Regina and Kramer were validly married and shall therefore affirm. Factual procedural background. Kramer died on June 21st, 2020. The personal representative of his estate was substituted as a Pele on July 31st, 2020. By two separate deeds, Regina and Kramer acquired as tenants by the entireties a condominium unit in Wintergreen Condominium Associate as well as LC Garage Space 306 and GC Storage Unit. We shall simply refer to both conveyances as the property or the condominium. Oh, my bad. Agreement and agreement and participated in a religious wedding ceremony. Their failure to obtain a marriage license is at the center of this appeal. We reprint the marriage agreement the parties executed on September 28, 2003. They even got a agreement in here. If you guys want to do it, you can follow this. In the presence of God and of the hereinafter named witness, I, Thomas E. Kramer, do take Waltraud Regina to be my lawful wedded wife. And I do promise to love, honor, and obey, to support her, be always faithful, cherish, hold, and care for her in sickness and in health until death do part. We do part. And in the presence of God and of the hereinafter named witnesses, I, Waltraud Regina, do take Thomas E. Kramer to be my lawful wedded husband. And I do promise to love, honor, and obey, to support him, be always faithful, cherish, hold, and care for him in sickness and in health until death we do part. I, Thomas E. Kramer, do recognize and hold these aforementioned marriage vows to be binding on me in the same way any civil marriage license and civil or religious church ceremony would be. I do also recognize and concede that Walter Regina has the same rights as if we were bound as husband and wife by a civil marriage license and civil or religious church ceremony. And I, Walter Regina, do recognize and hold these aforementioned marriage vows to be binding on me in the same way any civil marriage license, civil or religious church ceremony would be. I do also recognize and concede that Thomas E. Kramer has the same rights as if he were bound as husband and wife by civil marriage license, civil or religious church ceremony. By the signing of this marriage agreement and the taking and holding of the aforewritten vows, We, the undersigned bride and groom, in the presence of Almighty God and of the undersigned witnesses, do declare ourselves to be husband and wife. 4 attesting witnesses signed the marriage agreement. The Reverend Robert S. LaSalle, Sr. of St. Paul's Anglican Church in Annapolis, officiated the marriage ceremony and signed a certification that Regina and Kramer were joined together in the holy state of matrimony on September 28, 2003 in Crownsville, Maryland. The couple subsequently purchased as tenants by Entireties a condominium unit known as 8612 Wintergreen Court, Unit 306, Aldenton, Maryland. On March 4th, 2015, Regina executed a deed conveying her interest in the property to Waltrove Regina Living Trust. Regina established the trust in 1998 before meeting Kramer. The trust, a revocable trust, designated Regina as its initial trustee. An amendment to the trust in 2014 named Trapasso Regina's daughter from a prior marriage as the first successor trustee upon Regina's death or incapacity. Regina also executed a last will and testament in 2014 designating Trapasso as personal representative and bequeathing all of Regina's probate estate to the trust. Kramer is not mentioned in either the trust instrument or the will. Interesting. Regina died on June 18, 2016, and was buried with her first husband. Huh? On August 10, 2016, Kramer executed a confirmatory deed in which he recited that Regina purportedly conveyed her interest in derogation of her interest in property as a tenant by the entirety. The confirmatory deed further recited that as a result of Regina's death, Kramer was vested with sole title to the property as the surviving tenant by the entirety. Trapasso, as substitute trustee, filed a petition to acquire title and for sale in lieu of partition of real property in order to discharge proceeds, seeking a declaration that the trust owned 50% of the property. Kramer filed an answer to the petition disputing validity of the March 4th, 2015 deed conveying Regina's interest in the property to the trust. Sounds like she did all this behind his back. A bench trial took place on September 21st, 2018. No live testimony was presented. The parties agreed to submit their cases based on proffers and extensive documentary evidence at which was admitted without objection. The court received the depositions, testimony of Reverend LaSalle, an ordained priest of Anglican Church. Reverend LaSalle verified that he presided over the September 28, 2003 marriage ceremony in accordance with precepts of the church. He noted that he had known the couple for approximately 7 years before they approached him about getting married. In addition to the deeds at issue, the trust documents, and Regina's last will and testament, the parties submitted evidence bearing on whether Regina considered herself to be married to Kramer. That evidence included documents verifying that Regina was receiving Social Security benefits based on her first marriage and that she maintained accounts with Verizon, AT&T, as well as bank accounts solely in her name. Regina also represented to the Internal Revenue Service that she was single. On the other hand, there was evidence presented that Regina co-signed an auto loan with Kramer and held a joint checking account with him. Circuit Court determined that Regina and Kramer were validly married under Maryland law by virtue of their religious wedding held on September 28, 2003. So the court, even though they didn't get a license, said that they were validly married because they did it with their church and they signed a contract. Remember what the Constitution says, they cannot abridge private contract, your right to private contracts. I've been telling y'all that. You know, in doing so, the court found that the marriage agreement and related documents included almost every component of what might utilize their preparation of a marriage. So you can't just do a religious ceremony. You have to document it like they did and have witnesses. That's all it takes. So this shows you don't need a marriage license. Accordingly, the court declared invalid Regina's deed conveying her interest in the property to the trust and concluded that Kramer became the sole owner of the property upon Regina's death. The court entered its order on October 28th, 2018, from which Trapezo in her capacity as substitute trustee timely appeals. We are asked to answer a straightforward question where Regina and Kramer validly married under Maryland law despite having never obtained a marriage license as required by Section 2-401 of the Family Law Article. Because Maryland precedent requires us to answer yes to that question, we hold that Regina's deed purporting to convey her interest in the property to trust was a nullity. We begin with some basic principles of real property law. A tenancy by the entireties may only be held by a married couple. Young v. Young, 3-7 Maryland Appellate Pills 211, 216, 1977. If the marriage is dissolved through divorce or annulment or is otherwise invalid, the parties would instead hold the property as tenants in common or joint tenants. In a tenancy by the entireties, one spouse generally may not act alone to convey an interest in the property. The other spouse must assent to the conveyance of the real property article. This is in contrast to tenancies in common and joint tenancies, which allow a single tenant to convey his or her interest in a property without permission. So basically, you cannot, based on the law of your state, you cannot convey a property into a trust without the other one's consent if you're married. Okay. Thus, if Regina and Kramer were married, Regina's March 4th, 2015 deed conveying her share of the property to the trust without Kramer's assent was invalid. Trapezo argues that Regina and Kramer were not validly married because Family Law Article Section 2-401A and 2-406E require parties to obtain a marriage license before marrying. Maryland Code 1984 and all those other numbers of the Family Law Article, Trapezo avers that because a couple cannot create a common law marriage in Maryland, a marriage license is a prerequisite for a valid marriage. Kramer responds that applicable case law clearly holds that a ceremonial marriage without a license is sufficient to constitute a valid marriage in Maryland. He claims that Florida Section 2-401 creates criminal liability for marrying without a license, but does not nullify the marriage itself because the statute is in derogation of the common law and does not expressly state that such a marriage is void. Section 2-401 of the Family Law Article states in its entirety, an individual may not marry in a state without a license issued by the clerk for the county in which the marriage is performed. B, any individual who violates this section is guilty of a misdemeanor and on conviction is subject to a fine of $100. Section 246 of the Family Law addresses the requirements to perform a marriage ceremony. It states in pertinent part, an individual may not perform a marriage ceremony without a license that is effective under this subtitle. An individual who violates the provisions of this subsection is guilty of a misdemeanor and on conviction is subject to fine not exceeding $500. The Court of Appeals articulated the principles of statutory interpretation. In statutory interpretation, our primary goal is also to discern the legislative purpose, the ends to be accomplished, or the evils to be remedied by a particular provision, be it statutory, constitutional, part of the rules. Y'all better listen carefully. We begin our analysis by first looking to the normal, plain meaning of the language of the statute. Reading the statute as whole to ensure that no word, clause, sentence, or phrase is rendered surplusage or superfluous. Man, I'm tongue-tied. Meaningless or nugatory. Further, an interpretation should be given to the statutory provisions that does not lead to absurd consequences. So basically, it's saying when a law is created, it shouldn't cause harm. You know, it shouldn't be a law that, restricts your rights. So, Further, an interpretation should be given to the statutory provision that does not lead to absurd consequences. If the language of the statute is clear and unambiguous, we need not look beyond the statute's provision and our analysis ends. If, however, the language is subject to more than one interpretation, or when the terms are ambiguous, when it is part of a larger statutory scheme, it is ambiguous, and we endeavor to resolve that ambiguity by looking to the statute's legislative history, case law, statutory purpose, as well as the structure of the statute. Even in instances when the language is unambiguous, it is useful to review legislative history of the statute to confirm that interpretation and to eliminate another version of legislative intent alleged to be latent in the language. Additionally, statutes in derogation of the common law are strictly construed, and it is not to be presumed that legislature, by creating a statute, intended to make an alteration to the common law other than what has been specified and plainly pronounced. Therefore, statutes related to the validity of marriage are merely directory unless the statute clearly indicates a legislative intention to nullify such marriage. There is an ambiguity within a statute when there's just two or more reasonable alternative interpretations of the statute. The plain language of FL section 2-41 could reasonably be read as either declaring unlicensed marriage invalid or therefore avoid ab initio, or merely encouraging licensure through the creation of a misdemeanor punishable by fine without nullifying the underlying marriage. So basically, they're saying it's a violation to marry without a license, but it doesn't necessarily nullify the marriage if you did it. That's really what this is saying. Because the statute is ambiguous, we must look outside its plain language to determine whether an unlicensed marriage is valid. Fortunately, this particular question of statutory interpretation has been resolved in prior cases, most notably over 100 years ago in Feely. For background, we note the difference between a common law marriage and a ceremonial marriage. It is well settled that a common law marriage may not be created in Maryland. However, the phrase common law marriage is often misused. The phrase common law marriage refers specifically to one form when a couple agree to be married, hold themselves out to be married, and cohabit as married couple without participating in a formal ceremony. These actions by themselves have never been recognized as forming a marriage in Maryland. So what they're saying is, if you just get together and say we're married without doing a ceremony, then that's not recognized. But these people did a full-on ceremony. The common law of England recognized another type of marriage, a ceremonial marriage, that is one solemnized by a religious ceremony. Ceremonial marriage were the only type of marriage ever recognized under Maryland's common law, either as a colony or as a state. With this background in mind, we turn to the case law that controls the resolution of this case. In Feely, the parties were married in 1891 and divorced in 1896. In 1915, they reunited and without first obtaining a marriage license, participated in a religious ceremony where the parties understood that the priest was officiating there in order that they might live together in lawful wedlock. Approximately a year later, the wife filed a complaint for divorce seeking alimony and division of property. The husband's defense was based upon the theory that the parties were not lawfully remarried. The relevant statute provided that no person within the state shall be joined in marriage until a license shall have been obtained from the clerk of circuit court for the county in which the marriage is to be performed. The husband therefore contended that the failure to secure a marriage license rendered the marriage void. In determining the validity of the marriage, the court considered the purpose of the licensing statute as it related to the common law. Under Maryland's common law, a religious ceremony in celebration of civil contract was sufficient to make the marriage lawful. There you go. I don't even think I have to read this anymore. That's enough. I done read enough. I done read the whole, except for 2 pages of it. Yeah. There you go. Somebody sent me something. Uh, oh, let's see that. All right, somebody send me a text. So, there y'all got it. Y'all don't need a marriage like long as y'all get a contract, sign it, go and do your get somebody to marry you. I have the credentials to do it. Those container trailers may be loaded with weapons inside those ship. Oh, oh. I am 18 and words spread like fire. They talking about weapons inside there? Really, in Mexico? Weapons for who? Yeah, so there you got it. No license is required. Just do your ceremony if you don't want to get the license, But if you want to get the license, do that too. It's up to you. Alpha Majection said he loves your channel. Thank you. Thank you. What do you mean by these container ships out there? Word spread like fires in our community. They just sitting out there doing what? What the weapons are for? All right, y'all. It's 8:33. Let me see. Let's go back to Blog Talk. Still nobody got their hand up. All right. Well, in that case, I'm going to shut it down. It's in the whole process of marriage with two witnesses on their religious belief. Well, these people have 4 witnesses, so in their situation. Well, with that being said, y'all have a good night. Peace, prosperity, extreme wealth to everybody. And I am going to turn it in.
Peace to the gods. You're listening to Hindsight Radio. This is Hindsight Radio. I represent it. The information station changing the nation.